हेलो।
Yeah.
हेलो, अभिनव।
यस शेजिल।
यही वाला है ना, बिकॉज़ मुझे कोई दिख नहीं रहा है यहाँ पे, मतलब आपके अलावा।
नहीं अटेंडेंस आना
नहीं,
शुरू हो गया
अटेंडेंस
है।
आना शुरू हो गया है। ओके, ठीक है, ओके।
आपको सबको टकर टकर। We will be starting in a few minutes. Just please wait. Uh, Good afternoon, sir. Good evening, sir. Sorry.
I will
Okay.
be
Good evening, everyone. A very warm welcome to all of you on behalf of the Indian Pharmaceutical Association Delhi State Branch and the Indian Pharmaceutical Association Student Forum Delhi State Chapter. I am Abhinav, Council Member of IPA Student Forum Delhi State Chapter, and your host for this session of our exclusive webinar series Know Your Profession. I welcome all the participants joining us today, along with the leader of IPA Delhi State Branch, Dr. Saurabh Arora, Chairperson, IPA Delhi State Branch. And a special welcome to our esteemed speaker for the day, Mr. Amrish Tiwari. Know Your Profession is an initiative designed to guide pharmacy students in exploring diverse professional avenues that lie ahead by connecting them with leaders from industry, academia, and regulatory sectors. Each webinar helps us answer one key question: what lies ahead after BPharm? And today's session takes us into an area that forms the very foundation of innovation: patents and intellectual property rights. In the fast evolving world of life sciences, innovation is the key driver of progress, from new drug molecule to advanced biotechnological invention. But behind every successful innovation lies a strong patent, safeguarding the creator's idea and ensuring that research is rewarded and protected. Today's session, Decoding Patent, Protecting Innovation in Life Sciences, will help us understand how patents play a crucial role in encouraging innovation, driving research, shaping careers in IP law, and regulatory affairs for pharmacy professionals. To share expertise on this fascinating and essential domain, we are deeply honored to welcome our distinguished speaker, Mr. Amrish Tiwari, partner and patent attorney at KNS Partners. Mr. Tiwari is an accomplished IP expert and a legal strategist with over 2 decades of experience across biotechnology, pharmaceuticals, and emerging technologies. His expertise cover patent drafting, prosecution, opposition, litigation, and IP strategy, making him one of the leading voices in the field. He also served as the chair Artificial Intelligence and Robotics Subcommittee at the International Bar Association and has been featured in IAM Strategy 300, IAM, IAM Patent 1000, and MIP's IP Stars. Mr. Tiwari is also a gold medalist in pharmaceutics from the University of Delhi. We are truly honored to have him with us today to help us explore how innovation in life sciences is protected through patents. Over to you, sir.
uh, Thank you so much, Abhinav. Uh, Good evening to all the students. I mean, I can't see any one of you, but I believe they are students, and I can just share, my journey, and also, maybe make you more aware about this IP profession, intellectual property rights. So I started, after my 12th, I joined College of Pharmacy in 1999. And I was preparing for medical, and then, I could not clear medical. And I was guided by my seniors to, pharmacy is one of the best thing if you are, after medical. So I joined pharmacy in 99. I did my B Farm in 2003, and then I did my master's in pharmaceutics from same college. The name changed to Delhi Pharmaceutical Institute of Science and Research that time. I joined. They were campus placement during 2004 to 2005 time. I got offer from Dr. Reddy's. I don't want to move from Delhi, so I also got offer from Clini RX. I mean, clinical trials were the new thing that time. But same time, I joined that firm in 2005 for a few months, and then I got a call from this law firm. This law firm used to be across our college in Sainik Farms. His name was KNS Partners Kumaran and Sagar. And how I was introduced, because our college used to file patent applications. Our principal and few of the faculty members, they were filing patents for the US and also filing patents in India. And at that time, I have applied for a patent. I was one of the inventors along with my guide. So we applied for a patent, and I used to this law firm used to call me for a while drafting of a specification. They had few questions. What is the invention all about? What was the prior art? So that was the background, and they were looking. 2005 was a time when there was a change in law, and a product patent came into India. Before 2005, only process patents were allowed. So 2005 was an opening of market for the pharmaceuticals, and there was a big opportunity when you can move into the legal side. So not many, and not I didn't know anyone who had joined law firm after doing masters, but I mean at that time my managing partner in the firm, he convinced me, make have a try. You have to appear for a patent agent exam, and you have to also do a law. So I did my law, 3 years law from Delhi University after doing my master's in pharmaceutics. So that time we had a evening classes. I was doing job, uh, 9 to 5 or 6, and evening I used to attend, law classes. So North Campus law center one, I was there. 6 to 9 was classes, and by 10 I used to be back home. And three, attendance was a big issue. So that was my journey. I mean, and why I got into IP side. Not many of you are aware. I mean, hello, can you see me? Yeah. Or there's something coming. Okay, I have to approve. So not many of you are aware. I mean, the law firm or legal side is one of the careers where you can get into equity, profit sharing. Like the legal, we all come from the science side. All come from the mindset after 12th. You have done well in 10th. So either you are taking medical or non-medical, and then you are appearing for exam or enter into science. But the legal is a different world. And in the law firms market, you can become partners, you can become equity partners in profit sharing, and there's no limit to that game. So I was sold this dream when I was a young boy. One day, if you do well, you do your law, you can be into the profit sharing. Vis-a-vis, when I was applying for the different pharmaceutical companies, the job offers were mainly for a employee. You come, this is your package, and there was nothing like something called profit sharing. So I was more inclined towards profit sharing. If I can bring client, add value, bring business, and do well, then and that has actually happened with me. So that was my journey. I mean, otherwise, I never knew any seniors who has joined law firms that time, and the dream of becoming a profit sharing partner or equity was something I decided maybe if I work for 10 years, I would like to be sharing profit rather than working for a company. And that eventually came through. I mean, now I'm in this firm for almost 20 years, more than 20 years, and it's been an excellent journey. And The only challenge is, either you do diversification is always good. Do your technical thing, do your bachelor's or science degree, then either people, pursue your management MBA or go for a law. So that is a something. I mean, if you have dual degree, diversified degree, that can could be better way of looking things. Obviously technical, pharma, masters, PhD has a great scope, and most of the students go abroad and eventually join pharmaceutical companies. So I mean, this was a bit about me. I thought I will just give update why I choose law firm, and law firm were not known, and I was a gold medalist in my batch. We had a Sheila Dixit. She came, and I was one of the topper, and that's why I got this opportunity working there. I tried. I thought if nothing, worked well for me, I can come back to my industry. You can always come back to your own industry. You can always get a job, after 3 or 4 years. But doing law opened my eyes. I mean, they nothing because they had 50 subjects in law, and you have to do some 30 subjects, 6 semester. Every semester they give you some subject you have to choose, and it was very interesting, very general. I mean, for the science student, law is very easy, but it's open your eyes. I mean, you get more awareness about basic law, basic rights, civil procedure right, criminal procedure, evidence act. It give you more empowerment, in that way. And doing law from Delhi University was, so that was my journey. And I encourage people to keep your eyes and mind open. Don't restrict yourself only for the technical, courses where you are in. It could be good. You have joined pharma. There are many things, but also keep your eyes open if there is a management possibility. I know many of my colleagues, many of alumni who eventually did, MBAs from IIMs after bachelor's. Or I have my friends. We were four friends, different journey, and I mean they did MBA from IIT Delhi. So these, and sometimes, diversification has really helped us in our career. So I choose law, and I'm always grateful for the law. I mean, if I'm again given a chance to go back 20 years back, probably I will do law after B Farm, not after M Farm. So, but doing law after M Farm was great. And regarding IP, I mean, many of you may not be aware. Intellectual property is probably in developed country, it 150 or 200-year-old career. In US, in Europe, market like Japan and Korea, you find people with the technical degrees appearing for a patent agent exam, and also pursuing law. So mixture of techno legal. And it's a, well, I mean, if you go through the profiles of patent attorneys in US or Europe, you'll find people with a master's, PhD, and the legal side of it. And it's a very lucrative career. It's a very, believe me, trust me, it's a very lucrative career. Sometimes it's demanding. It's more lucrative if you get into the contentious side of it, enforcement side of it, or eventually into the litigation side of it. Otherwise, even in the patent, hardcore patent is a, is very lucrative. It's very lucrative in US, Europe, and especially in India. So this is about the background. Anything specific you want? Otherwise, I can just, I know the time, whatever I've been given is not also much where I can cover all the topic. I can only give you, glimpse of what is IP, and, what is patent, what is the requirement of patent, and what are not patentable inventions, in India. Unless if there is any specific thing you want to hear, because many of the things you will get, there are many speakers. Even you type on the YouTube, you get basic information. Anything which is going to help a student, I'm more than willing to share the practical information. I'm more here to help, and give you the resources. And maybe I'll cover, I have also slide, I can also cover through the basic act, how you need to see the act. Yeah. So how you want me to go, Abhinav, Adya?
Mute, Ade, mute.
Am I audible now? Good evening, sir.
Yeah.
Yes, yes,
Yeah.
yes.
We do have a set of questions from students, but if you have a presentation to cover, like a few minutes,
Okay.
then
Okay.
15 minutes. But
So
we do have
maybe,
a set
okay.
of questions that is about the a roadmap and
Okay.
how to just go beyond BPharm and look into the patent side.
Okay. So what I'll do, I'm indicating I have a briefing around 6:30. I need 10 minutes for preparation before that. So I'll give 10-15 minutes. I have slides also, or maybe other way of looking into directly going to the act. So I'll maybe for 15 minutes, I'll try to give some overview, and then I'll jump into the questions. Otherwise require more time.
Yeah, makes sense.
Don't
So
get me wrong. Yeah.
Yes.
that works.
Yeah.
That works.
So I can share the screen, huh? I guess.
Yes, sir.
Okay. Or not. Can you can you guide me how I can share my screen? Any uh, tools? No. How? I mean, can you let me know? I mean, I'm a bit lost here.
Sure, sir. One second.
Like in Teams and Zoom, it's easy to click and share your screen.
Yeah, sure. One second, sir.
Audio change.
Hello, Amrish sir.
Yeah.
From left hand side, a plus sign. You can click on that.
Okay.
Share the screen option. Fourth option is share the screen.
Okay. Got it. Thank you so much. Share the screen. Now I use 2 or 3 screens. Okay. Got it. Window. Okay. I'm sharing. So can you see my screen? Okay.
Yes, sir. We can see it.
You can see it.
Yeah.
Okay. I'll move. Okay. So I mean, basic. I will be a bit fast. I hope. Can you see my screen? Yeah. Yeah. Okay. Is it or it's coming? Just a minute. Okay. I don't know why it's not coming in your. Okay. Okay. Just a minute. Just a minute. So anyway, IP is so I'm a bit lost. I mean, my screen is visible.
Yes, sir, your screen is visible and we can also hear you.
Okay. Okay. I'm so sorry, guys. Okay. So I mean, so on the intellectual properties, basically I'll cover, what kind of IPs we have, and we say it's just a creation of human mind. Anything which is intangible, how it can be protected by law. Just like we have real estate, and this is a so in IPR we have 7 forms. I hope uh, you all know these specific terms. There is something called patents, and people use them interchangeably. And in a IP, whenever we call IP, intellectual property rights, everything come, in this. Okay, where is that? So this is a screen. Okay, so it's come patent, trademark, copyright, design, plant variety, geographical indication, trade secret, and Semiconductor Act. I mean, it's not move. Okay, it's moving now here. So just to give you, I mean, but the basic difference in patent is all about inventions. You have to file application and examination. Anything technical about innovation cover under the patent. Copyright is all about a creative and artistic form. Uh, it exists automatically also. Trademark or the brand names is all about distinctive identifications of product or services. Is covered with the use and registration, and something we also call designs. The trademark is different, design is different. Design is only for the external appearances. Like there is a bottle, even the design of bottle, and then there is a trade secret. We have a bill pending with the parliament. There is a draft bill ready. As such, we don't have trade secret act in the India, but now there is a bill how to protect trade secrets, and it's different from the patent copyright, thing. And so you require good effort to keep your trade secret as a secret or confidential. Patent, always there is a term, and all these IP rights are territorial rights. If I say territorial means, for India, there is a specific, you have to apply all these IP rights in India. If you are going for the US, you have to apply all these IP rights in US. Similarly, in Europe, Japan, Korea, worldwide. So is bounded or restricted with the territory. So patent is for the 20 years, and copyright, is either through the lifetime of the author or 60 years from the year in which author dies. Trademark is 10 years, and they all can be renewed. If similarly we have a design law, any new design you can protect for the 10 years, and it can extend for the 5 years. Geographical indication also 10 year from the registration, and it can be renewed time to time. And we have Plant Variety Act, and that plant variety, the timelines is 9 years for tree and vines. And similarly, this is just on the procedure, just to give the basic idea about. Hope you know trademark. I'll not devote time here. I mean, as you can see, all these symbols, sign, word, slogans, they are all called trademark. So this is a different form of IP right. Here, anyone who is a lawyer or a trademark agent, they normally pursue this trademark. Even a pharma with a lawyer, they can also do. In pharmaceutical trademark, you find the brand names for each and every drug, and it's a very competitive, field. Dealing with the pharmaceuticals brand names, and there are a lot of oppositions and revocation. So it's a good, opportunity, especially people from the pharma and legal background. Generally, simple lawyer can also deal with this, but coming with the pharma degree obviously help. Design, I mean, okay. Nothing nice. It's the outer shape and appearances. Uh, Anyone from the technical degree or a patent agent can also pursue design applications before the patent office. This is copyright. Why showing? Okay. And copyright is all original work of authorship. So normally only lawyers they are involved in the copyright matters. But something this is different from the other forms of IP right. If you call about IP firm, they do all. Patent could be the big business. Geographical indications. I mean, you have heard of Dazzling tea, or or specific wines and spirit, Scotland whiskey. So all these are anything grown in the particular area that the group get this right for the geographical indication. Okay, this for the plant variety. So these all are different 7 or 8 laws, and just the broad view. And here you can protect all the plant varieties, and there is way. So it's require your technical background and the legal awareness. So now if you come to the product, there are multiple IPR. For simplest example, could be this phone. If you divide trademark, it made by Nokia, product is N95. And similarly for the patent, they are whatever the technical innovation involved in terms of data processing method or semiconductor circuit or even the chemical compound for the glasses and things, they all are covered in the patent. Copyright could be software code also. Software per se is not allowed in patent law. Is also allowed in copyright, but there are ways and means to protect programs and software related, computer related inventions in the patent. Trade secret are not protectable, but there is something which is, as a lawyer, we should be aware of. And similarly, we have a design, the overall appearance and other thing you classically see in the iPhones and Samsung phones. That is called design. So this is patent. Normally we call it a negative right because it's a monopoly. If you're applying for a patent, government give you monopoly to inventor or assignee for 20 years in exchange of your information. And you have a right to exclude others. And these 5 rights, others cannot make your invention use your invention, offer for sale your invention, or importing the patented invention. So these 5 sets of right are very important under the Patent Act. If you have a patent in India, you get monopoly to exclude others for all these 5. Export is not there. Because why? Because it's a territorial right. Anything within India can be protected. If anything is exported in that particular country, then the law of that specific country will come into play. So export is not there, but before even exporting, how someone can export? Either he will be making it or offering for sale in India. Then you can also get hold of the infringer who is exporting the product. And this is a in a law definition given. If you are giving a solution to a specific problem, and that is a product or process, that is you can get a patent. In our country, method of treatment, especially from the pharmaceutical and life science and biotech side, in our country, method of treatment, use, or switch type claims or new use are not allowed. But in many other jurisdictions, these claims are allowable, like second medical use. If you have already known drug used for a painkiller, but now it has a use in cancer, that is not patentable in India, but is allowed in Europe. It's allowed in other market where either you can draft your claims in terms of method or use. And this, yes, negative right and territorial right. So these 3 things are fundamentals. I mean, we always say problem solution approach. I mean, there should be some problem in the prior art, in existing knowledge, and you are giving some solution to that problem. And your patentability depend on these 3 factors. Is worldwide. Forget India, everywhere. Your invention need to be novel. What we call novel means it should be new, absolute new. It should not be mentioned, published in anywhere worldwide. So that is called novelty standard. So your invention, if it's new, is cross one of the parameter. The main thing come inventive step, and for that we have a job of a IP lawyers or patent attorneys. We have to define what is inventive step, and there are different interpretation of inventive step. There are different definitions and approaches in different countries. US has different approach, Europe has different approach, India has also different approach, and it's evolving from time to time. The matters goes to the court, and the court define how you see inventive step. The definition of inventive step in the act is, if your invention is non-obvious to a person skilled in the art, or it has some technical advancement over existing knowledge or economic significance, that how inventive step is defined. And third parameter is industrial application. I mean, whatever invention you are proposing, it has to be has some utility. So it's easy to get novelty. Obviously, whatever we are inventing is easy to get industrial application or utility. But inventive step is tricky, where you have to draft. Our role comes into play, where we have to draft what was the story in the prior art, what were the kind of inventions were known, why this, what were the problems people were facing, maybe in terms of drugs or formulation, and what we are proposing. So these 3 parameters define. If you're able to argue well and get over these 3 issues, you get a patent. Okay. I mean, there are many things in new product and new, as said, it could be composition, drug, and all. I'll move to the next. So there is a lag. Okay. So these are some advantages of patent. I mean, this gives you first mover advantage in the market. If you have a, if you are in a businesses or big company, it's always give you first. It has huge monetization prospect for the innovators, for the companies, and in many countries, even the scientist is linked with their remuneration, their salaries. There are licensing opportunities, especially in telecom and all. I mean, more numbers of patent they have, there is a big licensing opportunities and big revenues they get from the patents. Obviously, good for the investors. Exclusive right for preventing misuse and exploitation of inventions is help industry to improve existing technology to produce cheaper and better products. Is avoid duplication of research and obviously encourage inventors and society. Okay. So this we discussed already. I'll not again novelty, inventive step, and utility. I'll just move to what are not patentable in India. Each country, every jurisdictions have certain limitations. US also have some limitation. Europe also have limitation. Japan, Korea, Canada all have limitation. Our country has many more limitations. We have Section 3 in the Indian Patent Act, which defines what are inventions not patentable in India. And we from Section 3A to 3P, they have listed, these kinds of inventions are not patentable. So these are, I'll give you, for example, first two bullets, they are not patentable everywhere. For example, any abstract idea, theory, or natural phenomena. If you come with these things, they are not patentable everywhere, anywhere. Second thing, naturally occurring things or mere discovery of a new form of a substance. Naturally occurring thing, we have case law. So you cannot simply pick anything from the nature and claim it, you want patent over it. If there is a human intervention is involved, you take that, normally for the biotech cases where you have bacteria and different strains. So if you are picking any specific strains, as long as there is a human intervention is involved, you are identifying it, characterizing it, then you can go for a patent. And these are some of the things which are not allowed, like new form of a new use of a non-product and processes are not allowed from the pharmaceutical standard. Mere admixture. What is mere admixture? Simply A plus B or 1 plus 1, 2 is not allowed. But 1 plus 1, more than 2, 1 plus 1, 4, 1 plus 1, 5 or 6 is allowed. So there is a legal twist in that. And it's a debatable what could be the admixture and what is not. Then these are for the mechanical arrangement, rearrangement of known component. For example, you have a helmet, you putting torch over it, and saying, this is a, and you putting some more known component. So just simply arranging and rearranging known component, these are not patentable. Method of agriculture and horticulture, they are not patentable under the Patent Act. We have a Plant Variety Act that deal with the different method of treatment or surgery, anything which doctors are doing. This is not patentable. Plant, animal part thereof or production thereof. And this is very interesting for the people with the engineering background. Anything computer program, business method, or mathematical models are not patentable. Their job is to make them patentable. Method of teaching, learning, playing games are not patentable. Artistic creations, is fall into the copyright side of IP law. It's not patentable in patent. Semiconductor layoff design, we have altogether different statute. Traditional knowledge is not patentable. I mean, anything which is this is very peculiar to India. Anything now we have TKDL, our library, digital library. Anything Unani, Ayurvedic, or our traditional knowledge, which you can show evidence by oral or written means, saying this was already known. There no new invention. For example, when I joined the firm, my job was to revoke patent uh, for neem and turmeric in US. So someone got patent for neem, properties of neem and turmeric in the wound healing in the US. And we filed a position for that, and government approached us, CSIR, saying, this already known is the traditional knowledge in India. We have to revoke. It's a government sentiment. So we literally have to, took out the document which were 50 years or because and in the law you have to, give evidences, why is the traditional knowledge in your country. So we gave evidences, we gave translation, we gave certificates of authentic translation, and they restricted their claims. Okay, not for the healing, only for the during the maternity procedure, it used for the wound healing for that. Even we got that evidence for that, and eventually, these patents were revoked in US. uh, So these are basic same section, 3C, 3D, 3D. You keep hearing in India. I mean, it's very particular to pharmaceuticals. We say 4 or 5 things, but main is new use is not patentable, and any second generation product, salt, ether, polymorphs are not patentable unless they show enhanced efficacy as compared to the known substance. So my job in last 20 years to show, salt, polymorph, ethers, or whatever non-patentable in these sections are patentable. So that what I've been doing, to build a case technically and the legally, and to argue, the innovations don't fall into this. If you look from this side of argument, rather your polymorphs are patentable, salts are patentable, and I'm meeting the criteria. And what kind of admixtures are not patentable? Sometimes they say, your formulation, your composition, it has 2 ingredients, like your combination patent. You have 2 drugs, individual drugs are known for their activity, and now simply you are giving in combination is not patentable. Yeah, most of the time people can argue these are not patentable, but there are many times, it's not simply, it's also require innovation to put different drugs into combination, and they are different excipient, and they are, if anything not given in the literature, it could be patentable. So I mean, this what we do, and expected from the, us, if you join the IP side of it. Okay, looking into time, I'll just move fast, and maybe we'll come to. I mean, this is bit detail how you can draft patent application. I mean, especially if they are audience in masters and PhD, they know, whenever you write your thesis, you do literature review, and that is literature review. Any background check, what kind of information is already known. So that is conducting a prior art search, whether invention is patentable, any publication issued, any you have to list problems in the prior art. What is the problem solved by the inventors? What is the novelty? Is the solution obvious? I'll just move. For example, solution proposed, whatever solution is proposed, there has to be industrial applicability. It should not be like, you're coming with the innovation and no one want your innovation. Either it's too complicated, complex, or it has no market for it. It looked like a new. Someone say it's non-obvious also, has inventive stuff, but can you really sell this product in the market? These are some of the examples, from different labs. Uh, what kind of innovations can come from chemistry, pharmacology, biotech, pharmaceutics, and agri. Uh, what kind of application can be filed, claims can be filed. So I'll move next. Yeah, because it could be a question, who can apply for a patent? Any person claiming to be true or first inventor of the invention can apply. Any person being the assignee means applicant of the person claiming to be true or first inventor. For example, you are in a college, you could be an inventor, but your assignee will be the college, because this is the faculty you are using, or so you along with the college or DIPSRU can be assigning. or by legal representative of disease. So sometimes, if inventors is no more, then any legal representative can also be an inventor. The law is very simple. First to file. I mean, you may have innovation, but you have not filed first. The law is very clear. Even in US, when I joined the practice in law, it was first to invent in US, but US also now follow first to file. So first to file is law in India. Whoever file first get the rights. And apply. We always say apply for a patent before disclosing it to anywhere. I'll just move. Okay. I think it will come. So just to give you the idea, what is patent? I mean, I don't know how it will come. So if you see, I mean, this is a house. So this boundary are the claims. Where is gone? Okay, this boundary is a claims. So whenever you draft a patent, you disclose your invention. You write about your invention. You give background. You give detailed story. You give example. Eventually, you protect claims, and claims are the final. You list the number of claims, and these boundaries are your claims. This could be your main invention, but the boundary we set, that is the claim, and anything outside that is called prior art. Anything in the public knowledge. And within this claims and main invention, whatever the field is, we call description. The description is you have to give what is your invention, all kind of example, whatever support you can give. The boundary is important, that is claims. End of the day, the claims are important. The claim need to be supported, and your invention need to be protected within this claims. So similarly for the prior art, I mean, that what we do, we disclose, what is the problem with the prior art, and what is your innovation. This is required. Though in drafting style, one may argue it's not mandatory, but it's a best practice. Identify prior art and also define them. And this slide is just to give you the overview how we draft. When we say patent is nothing, is all about inventions and how you write invention. So so there are 8 or 9 parameters under which you write your invention. You have to give a title, suitable title. There is a abstract of some 400 500 words. You have to give what is the field of invention, from the pharma, from the engineering side, or going specific into what is the specific field you are addressing. We have to give background. Background means whatever the known in the art literature, and then come the summary. First you give summary, is all the writing drafting style, and then you give the detailed uh, uh, okay, detailed description of invention, then drawings, and finally come the claims. Claims become the most important part. So this is how you see any patent. You will find all these component in the patent. So I'll just show you some pictures and then I'll stop it. So we say, these are some of the mistakes of the inventors. Normally we find where is inventions are not kept secret until the date of filing. People disclose it, in the informal environment. I mean, I hope it's moving. Yeah, discussing invention in the public is the same thing. We keep getting invention which are not new. People come with the same thing and say, it's all about reinventing the wheel. This is very common. Many times we come, the invention is too complex than the problem on merits. You see, it can be solved by the smaller cutter, but people propose some bigger just to get a patent. And we have to say, no, not go for this underestimating the invention. I mean, this is a very small invention. You see that there is a needle, and this is how it can be utilized, and this was rather patented thing, and this was the prior art taken. So sometimes, invention could be simple, but as long there is a merit utility, it can be drafted and protected. Yeah, obviousness issue is ignored. You are not ignoring. I mean, whatever you are working on, it could be very obvious to a person skilled in the art. The person of your field is a very obvious. You have not looked into the all aspects of the invention. No commercial utility. And this is the biggest issue: research or filing delayed. I mean, people sometimes wait for the perfect inventions and keep working on it. So I mean, with this, and also just to give you idea, I mean, inventions are not novel or inventive. Prior art search is not done diligently, but these are some of the databases, free databases. Like you can type on Google, you get Google patent. Also, there is a USPTO, US Patent Trademark Office. In past is there, eSpace. These all are free databases, and there are also some paid databases which give you more, insights about innovations, patents. They give you summary, and they are also literatures. I mean, this you must be aware of. And this for the sequence and structure search. I mean, this basically for the invention in biotech side. So this is just one of the example, one of the simple invention, and simplicity is not bar for a patentability. Like this pizza saver, if you see, you find this in all pizza boxes. And if someone come to you and say, this is my invention, people may laugh at it, but this was, patented, and it was patented globally. Very technical for the mechanical drafters. They get excited whenever they see this simple thing, but it's really solved the problem, and it has commercial, value. Okay, so I'll stop it. I mean, only thing, I mean, just the process is you file a provisional application. Before filing, we always, as a lawyer, we say always sign a non-disclosure agreement. I mean, you do search and research, seek expert advice. I'll stop it. Okay, what I have to do? Cancel. Stop sharing. How I can stop sharing? Okay, I got it. Okay, so this was from the slides. Because looking into the time, I've any specific thing I can deal with it now.
Thank you so much, sir, for such an insightful and enriching session. So we will start on with the Q&A segment. Though you have already stated about the basic roadmap that you followed, but can you again share a basic roadmap for those who joined late? And because most of them are P-Farm students, so according
Okay.
according to that, thank you.
So, Bob, switch to AB. No. So, I mean, I was, telling to come into IP, intellectual property, or be a IP lawyer, specifically patent lawyer, you require a science background. You require a science background. So, if you have done your simple BSc, before me, the practice was there used to be lawyer. If lawyers are with the science background, because generally you find lawyers with the arts, humanity background or commerce background, but if lawyers are there with the science background, they can do patents. So the basic requirement, B Pharma is enough. If you have done your B Pharm, you can, and there are few courses also. You can come into the IP field. So B Pharm degree is sufficient. After that B Pharm, there are, two could be requirement, but these are long term. One is a patent agent exam. So government always conduct a patent exam agent examination once in a year. and they have two or three. If you see the papers, you have to clear that paper. So there is a technical paper they, and it's come from your act. Act means law book. We have a patent act, and once you clear that paper, you become a patent agent. If you are a patent agent, it's a good. The only power you get, if you are a patent agent, you can sign. You can draft application, and whoever draft the application, end of the drafting, end of the claims, he has to sign. And only patent agent or a patent lawyer can sign patent applications. So you get your stamp paper, stamp number, you get your number, you can sign. It's like a CA, no? You who signed the audited sheet. So, and it's not very tough exam. Nowadays, I mean, the passing rate is 10%. But I mean, believe me, people with your qualification can easily crack it. I cleared it when I joined the firm within first attempt in a 1 or 2 month. So I joined the law firm within 2 months. So that is a one requirement. In a long term, so there are two kind of career. One is a in-house. If you join the pharmaceutical company, there is an in-house role. You work for the company. You see what kind of innovation they have. You do, either they put you in the searching department or drafting department. Or if you are in a law firm like me, I joined the law firm. So I was told very clearly, we are legal services firm, and I am supposed to do evening classes, law. And if I do law, because in a law firm, unless you are a lawyer, you cannot become a partner. And partner means you can be a salaried partner or also profit sharing partner. So, and law is something because it's open your mind. I mean, because IP is in start of your career, 80-90% is technical. But once you are into the contentious or opposition side of matters, it's become 60 or 70% legal and 30% technical. If I go to the enforcement side of it, it become 90% legal and 10% technical. So patent matters. It's good to have techno-legal background, technical your B Farm, and legal law is the best combination. And then that all you require.
Okay. Thank you, sir. And another question we have is, how can we learn more about drafting and filing patents? Are there any free government or online resources?
So, yes, there are free resources. I mean, you go to WIPO. WIPO is a World Intellectual Property Organization. So, WIPO has free courses, and it's great to have these certificates. If you ask me, I mean, you can enroll into this WIPO courses. They have a courses on basics of patent, uh, 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 information. They have also courses on drafting. You know various courses. They are free courses, they are paid courses, and WIPO are global courses. The headquarters in Switzerland, Geneva, and they do online tutorials and all. So WIPO is one of the good source. Other thing, one initiative our Indian Patent Office has started. So you type on Google Indian Patent Office or IP India. You will taken to the Indian Patent Office website. They also look for the interns. So they train interns, but these interns are long terms, 3 months and 6 months. You get handhold experience with the patent office. That is also many people also apply for a government job, and patent office is on the government side of. They also require technical people. Na? I mean, if patent applications are filed in these field, then examiners are also from the technical background. So I find people with a master's and PhD are examiners, and I represent here my as a lawyer our clients. So WIPO is a people can note WIPO, WIPO, World Intellectual Property Organization. There are a good number of free patent courses. Indian Patent Office has also free courses, and they are and then the best thing, if you ask me, they are law firms. I see law students are they keep asking for the interns. So in the law, in the legal side, it's a well known thing. People apply for an internship, but in the pharmaceutical pharmacy side, I have not seen students are keen to do internships. uh, I get numerous CVs from law student in second semester, third, fourth, fifth, seventh, eighth. But it's good if you can go for a 1 month internship in the law firm, or anything, you apply and ask, there are sources, you will get hand of on experience, and you will learn something basic of drafting. There are many more information available on YouTube also. I mean, you can see basic, and because eventually, unless you work on the file, unless you work on the real innovation, the main experience will come from that. But the basics you can learn from the, patent. Or there is a manual also. There are different examples are given how you draft your application. So these are the sources. I mean, at BFARM level, I believe enough for the students.
Okay. So, sir, one more question is, what are the key elements that determine whether an invention is patentable in the life sciences sector?
I mean, it's a territorial right. If invention need to be filed in India, you need to see whether it's a patentable in India or not. So there are few things which are not patentable in India. If it's patentable, then there are three basic criteria. Novelty, the invention need to be new. New means it's not disclosed anywhere in the world, written or on the printed medium. It need to be new. Inventive step is something where your attorney can guide you. You say, because inventive step means two things: either technical advancement over existing knowledge. So what is the technical advancement? And in the science, in the pharma, in the life science, it's all about the data. If you have more data or evidence, you can show, either your this compound is better than the earlier compound, or this formulation solves some problem, or it's a low, early release, long shelf life. These kind of information required, or some animal data. So inventive step can be argued. So basic criteria, I mean, you depending, I mean, in India, your invention should not fall into the non-patentable list. It should meet the novelty and inventive step standard.
Okay. Thank you, sir. To conclude this enlightening session, I would now like to invite Adya Pasi, Chairperson of IPA Student Forum Delhi State Chapter, to deliver a vote of thanks on behalf of IPA DSP and IPA Student Forum Delhi State Chapter.
Thank you so much, Abhinav. On the behalf of Indian Pharmaceutical Association, Delhi State Branch, and Indian Pharmaceutical Association Student Forum, Delhi State Chapter, I extend my heartfelt gratitude to our speaker of the day, Mr. Amrish Tiwari. It was indeed an enlightening session, from covering diversification of courses and following something other than the technical field, and then having a roadmap to what actually do after BPharm. It was really enriching. And a sincere thank you to all our participants from different colleges. We had a great participation of about 70 to 80 students joining us and making the session interactive and meaningful. Special appreciation to the organizing team for their dedication and effort in making this webinar a success. Thank you once again, everyone, for being a part of webinar 4 of Know Your Profession series. Thank you so much. Thank you so much, sir.
Thank you all, and I wish you great luck and do well whatever you do. And feel free to reach out me. I mean, I'm on LinkedIn, and if there is anything, I can be help. I can certainly love to contribute. And all the best to you. And only last takeaway: keep your mind open. Coming to the legal is a great field. I can only say from my own experience. Thank you all.
Thank you so much, sir.
Take care. Bye bye.